For Heffron? I call the member for Heffron.
Mr Acting Speaker, the opposition doesn't oppose the bill, and it is a worthwhile piece of legislation. And it is a worthwhile piece of legislation because the government, as far as their law reform exercise, went through the consultation process. I have said repeatedly in this House that when it comes to law reform issues, that it is vital that the government engage in the detailed consultation process to get the bill right, if ever any bill's right, but to minimise the consequences of, or the incidental consequences or unforeseen consequences of various legislation as it intrudes in the common law. There is no reason or prejudice that flows to either the prosecution or the accused by moving these break-and-enter offences into Table 1 offences, because both the prosecution and the accused do not forfeit their right to a jury trial, but they maintain their election. Problems only occur in this area where as a result of some budgetary exercise, that people forfeit their rights for a jury trial, and this bill does not do that. In fact, the Sentencing Council observed in its review that there should be a further examination of the Crimes Act, and there should be additional offences added into Table 1 offences, because it is a more efficient way in which to provide justice for those offences that are within the magistrate's jurisdiction. The Sentencing Council cautioned and the member for Liverpool made reference to, there are very good reasons why the jurisdiction of the local court should not be extended beyond the current limitations, and there are very valid reasons for those. And I won't go into detail, but I do say that there would be a major problem if the government ventures down that path. And there are the reasons of substance relate to the detailed consideration required by judges in relation to sentencing people for indictable offences. Now, the concern expressed by the member for Liverpool, which is apparent to me, having practised in this jurisdiction, is whether or not the resources that are going to be provided are sufficient. The attorney has made no reference in the second reading speech to the number of cases that would end up before the local court, and that might be understandable because it may well be impossible to look at past decisions of the District Court to ascertain it, because each court has different, the local court and the District Court have completely different sentencing patterns. Nevertheless, I discern that simply providing one extra magistrate and two police prosecutors is not going to be sufficient to deal with the workload in the local court. The local court, whilst the attorney refers to it as the most efficient court system in the country, the local court is very much overburdened. Irrespective of whatever delays that might be asserted by the member for Liverpool, and he would be quite right because he undertook some detailed consultation before he contributed to the bill. But the reality of the situation is that magistrates are very hard working with huge lists. They now begin sitting at 9:30, and very few of them are able to finish at 4 o'clock. Now, I often observe during my time at the bar that it was always retired judges who always said courts should sit longer than the traditional 10 to 4. I can say this, for those of us who have practised and who have practised on regional circuits, where traditionally additional time is added to the court to try and get through the list, the level of concentration required by both judicial officers and practitioners is immense, and a human being has only a certain level of capacity to concentrate and absorb in great detail the material that is provided. And there would be very good reason why courts over the decades, if not the centuries, have traditionally operated between that period of time, between 10 and 4. If you went on circuit started adding even half an hour a day onto the court sitting time, I can tell you by Wednesday all the participants, both public defenders, Crown prosecutors and judges, are exhausted as they're trying to get through as they're trying to get through the list, and you do it for 3 weeks and you effectively can't walk after that period of time. I can't stress to this House enough the detailed concentration of the issues that judicial officers are required to consider. Tired justice is not just poor justice, but is bad justice. Judicial officers deliver justice. They are human beings, and they need to absorb virtually every word that is being said to them and read every document that is put in front of them. And so consequently, increasing the burden on judicial officers with, for example, in local court, which would, for table offences, become quite serious offences in that jurisdiction, may well have an overwhelming burden in an already tired magistracy. Now, in respect of matters of this nature that are being inserted into Table 1, it is true that it is a quicker way in which to dispense with these materials, and it is not an unfair way. However, simply moving a case from the district court into the local court to have the magistrate deal with it does not take away a judicial officer's burden in determining the sentencing principles that they need to decide. And these cases are not cases that should be rushed through, because whether or not a person is in the district court or local court, the subjective assessment of, say, an offender must be considered by the court and must be put before the court by those representing him, and whether that requires psychiatric and or psychological analysis, as well as reports from probation and parole officer. We are dealing with offences that are at the highest end of the scale for the local court, and the same sentencing principles are required to be applied by the magistrate as they would have to be applied by a district court judge. Now, judges these days, because there are rights of appeal to the Court of Criminal Appeal against errors of law only, there are no rights of appeal on matters of fact, and there's no rights of appeal simply because you want the Court of Criminal Appeal to give a different decision. So judges, as a matter of course, are giving lengthy and even greater lengthy judgments and remarks on sentence when they are sentencing offenders. Even though Justice McClellan about 4 or 5 years ago observed on the Court of Criminal Appeal, and the reference escapes me, when he observed that judges in sentencing offenders should not give detailed dissertations of the law in respect of sentencing of offenders. However, the complexity of sentence proceedings is that they are now, judges are delivering judgments and remarks on sentence for some hours at times in sentencing offenders. And I apprehend that the complexity of the process and the decision of the Court of Criminal Appeal are recipes for the delay in the district court. So if the government really wants to examine a way in which to reduce delays in the district court, it should be examining the practices that are occurring in the district court in respect of sentencing of offenders, and see why judges are required to take so long and why they are required to reserve their judgments. Many judges are fearful, especially those that aren't the most experienced in crime, and even those judges, in giving extemporary judgments and therefore falling into error and then being criticised by the Court of Criminal Appeal in respect to their judgments. So if you want to reduce the delays in the district court, have a look at the practice that is occurring and the remarks on sentence of district court judges, and ask yourself whether or not a judge needs to, when sentencing an offender for an offence similar to this that is being now will be able to be dealt with in the local court, needs to deliver a judgment that takes him an hour to deliver, whether or not that's a useful part of court time, and see where the fault lies. The fault doesn't lie with judges, it actually lies with the Parliament. So consequently, some simplification in that process is required. Might I have an extension of time, Mr Acting Speaker?
The question is that the member be granted extra time. Is leave granted? Leave is granted.
In terms of the local court, you are dealing with the local court will under this legislation, if amended, be required to deal with complex matters. There is no provision for additional solicitors from the Legal Aid Commission to deal with that additional workload. And so consequently, as I just indicated previously, the same work needs to be done by those representing an offender, irrespective of which court they appear in. If the same work is not being done, and when I say the same work's being done, I don't mean whether or not in a local court one doesn't call an offender to give evidence, as some counsel will do in the district court. However, which was never my practice. However, the reality of the situation is the same material needs to be obtained and placed before the magistrate for the magistrate to deliver their judgment. Now, just because there is a right of appeal from a magistrate's decision to the district court does not enable, and a magistrate's judgment is not reviewed with the same analysis on appeal as a Court of Criminal Appeal would review a district court judge's judgment. The same law and the same heads of consideration apply. So it is really vital that the local court be resourced. It be resourced by, firstly, additional Legal Aid Commission solicitors. I query whether or not one magistrate is enough to carry the workload. And of course, the additional issue that has not been referred to, which is a practical matter that needs to be considered, is whether or not the nature of the security that involves local courts dealing with offences of a far more serious nature need to be increased because of the nature of the matters, and also whether or not their resources as far as corrective services and the detention of those that are appearing before them whether those resources have been applied. So you can't just shift cases from one court to another, just throw one magistrate and a couple of police prosecutors at it and say we're going to resource it and look at it. Because as you add additional cases to an overworked bench, as you add more cases which are serious and more complicated, then you add pressure not only to the prosecutors, not only to those who represent the accused, which is effectively the Legal Aid Commission, but also onto corrective services who need to make provision for additional people that will be found to be in custody because the nature of the offences, both before they are dealt with and afterwards, and the additional pressure that will be placed upon the sheriff's officer and the security services of the court because of the nature of the matters. And that is without even taking into consideration, and in respect of some of these matters that will be dealt with summarily, will be subject to pleas of not guilty and hearings that need to be heard by the magistrate, which is more court time of more serious matters, of more people being in custody and more security being required. So it's not just as simple as simply a law lecture that the Attorney-General sought to give in her second reading speech. Now, our justice system has been the victim of the bean counters in the Treasury for quite some time, and the government has, because of the blowout in time limitations for hearing cases, which has impacted upon not just accused but on victims, upon police and everybody else. The reality of the situation is that they are seeking to add more to it, but the reality is that you need to understand the consequences of what you're doing when you start fiddling with allocating matters between courts. As I say, I do not oppose it. I think it's sensible. I think there are far more offences in the Crimes Act that can also be moved into Table 1, which would in the long term benefit everybody. But those things need to be looked at, and for heaven's sake, it is about time that the government of the day started looking at why the district court is being overburdened and the pressure on judges who are having to deliver the sort of sentences that they are delivering every day.